Criminal and Civil Procedures module. There are 9 lessons with their corresponding desired objectives to be achieved by participants within this module. At the end of these short lessons, participants should be familiar with the basic factual information applicable to criminal and civil procedures in the United States as well as the state of Ohio. Of course, we have to have a disclaimer, right? All the information provided in these short lessons is publicly available and provides a simplified view of criminal and civil procedures in the state of Ohio for participants to gain a basic understanding. Remember, procedures vary across jurisdictions, so it is important to always check the steps in the process in the jurisdiction you are working. This information is not intended to be construed as legal advice. Participants will also be able to identify key concepts along with their corresponding legal terminology and know how to use them appropriately. Participants will also be provided resources to complete the individual assignments and are encouraged to use the same to build personal glossaries by incorporating the legal terminology used in these lessons so they can interpret them correctly and use them appropriately into their working languages. Lesson 1. An overview of the criminal and civil procedures in the United States. The objective for Lesson 1 is to identify basic key differences between criminal and civil procedure in the U.S. According to Doinen, in the United States, there are 2 bodies of law whose purpose is to deter or punish serious wrongdoing or to compensate the victims of such wrongdoing. These are criminal procedures and civil procedures. There are similarities as well as key differences between each process. There are many legal definitions available in dictionaries as well as in glossaries. Please remember that glossaries are usually lists of terms for specific fields and may not always have a complete definition, much less all of the possible definitions for the term. Merriam-Webster's online legal dictionary defines criminal procedures as the steps taken and methods used in bringing and conducting a criminal action. Also, a course of study in the rules of procedure in criminal actions. Furthermore, as an adjective, the Law Dictionary featuring Black's Law Dictionary Online defines criminal as that which pertains to or is connected with the law of crimes or the administration of penal justice of which relates to or has the character of crime. Doinen goes on to say, criminal law deals with behavior that is or can be construed as an offense against the public, society, or the state, even if the immediate victim is an individual. Examples are murder, assault, theft, and drunken driving. Merriam-Webster's online legal dictionary defines civil procedure as the steps taken and methods used in bringing and conducting a civil action. Also, a course of study in the rules of procedure in civil actions. Doinen also stated, civil law deals with behavior that constitutes an injury to an individual or other private party, such as a corporation. Examples are defamation, including libel and slander, breach of contract, negligence resulting in injury or death, and property damage. It is now time to start identifying some of the key differences between civil and criminal, as well as any similarities. By the way, these are not listed in any particular order. One of the first ways to know what type of case we are talking about is to know how the parties are identified according to the type of matter. In a civil case, we're talking about private parties, individual versus individual. In a criminal case, the government, be it federal, state, or local, versus the individual. Please note, there are specific instances where a corporation can be charged, but only an individual can get arrested and/or sent to jail. The similarities are that the actions involved in the case will be examined with its corresponding evidence and compared against the applicable law. The differences are that in civil, only private matters are involved in the case, and that in criminal, the government is one of the parties involved in the case. A second way to identify the type of case is based on the legal terms used to identify the parties involved in the action. Specifically, the legal terms used to identify the parties in a civil case would be the plaintiff, that is the party who files the case or action, and the civil defendant is the party who responds. In a criminal case, the prosecution would be the government who files the case or action, and the criminal defendant is the party who responds. The similarities, of course, are that there is general legal terminology which applies to both case law. The difference is that each type of case law has its own unique terminology besides the general legalese used in all court matters. Please note, accuracy in legal matters is essential. Therefore, it is important that all parties involved have a clear understanding of the terminology applicable to the relevant case law. In particular, this holds true for interpreters who will need to know if there are different terms in their working languages depending on whether it is a civil or a criminal matter. A third difference is looking at what the case is all about, or what is the nature of the case. Civil matters deal with disputes between individuals regarding the legal duties and responsibilities they owe one another, wherein the court determines whether or not one party has caused harm to another party. In criminal matters, you deal with violations of statutes or laws that prohibit some type of activity, wherein the court determines whether one party has committed an offense against everyone in society or the state. The similarities are that the matter is brought to court before a presiding official. The differences are that in civil, the disputes are between individuals, often of a personal or business nature, and in criminal, it is a violation of an existing statute or law by an individual that is perceived as being a crime against everyone in society. A fourth way of identifying the differences between cases is to know what outcome the parties involved are seeking in the case. In a civil case, some type of remedy for the loss sustained by the injured party, such as compensation for damages, some sort of restitution, or specific orders to do or not to do something are being sought. In a criminal case, a specific punishment, such as jail time and/or monetary fines, as a way to deter the behavior and preserve the peace. In some situations, the punishment is also a means to offer rehabilitation for successful reintegration back into society. The similarities are that the parties are seeking resolution from the court in a presiding official. The differences are that in civil, we are seeking liability. The injured party is seeking compensation for damages and/or perceived loss, and in criminal, we are seeking guilt. The government, as a representative of society as a whole, is seeking a specific punishment or punishments for the actions committed. Another way to differentiate civil and criminal matters is according to the standard of proof that applies. In other words, what must the party bringing the case to court prove to win the case? In civil matters, there needs to be sufficient grounds that support the party's claim being presented. In criminal matters, the government has the burden of proof regarding the action or crime committed by the accused party. The similarities are that the parties involved in the matter have to support their case before the court and a presiding official. The differences are the standard of proof required. In civil, the preponderance of evidence supports the winning party's claim. In criminal, the actions committed by the individual have to be proven guilty beyond a reasonable doubt by the government, since the punishment affects the individual's rights of life, liberty, or property. The last difference pointed out here is who decides the case. While the Constitution protects the rights of every citizen, civil and criminal matters can and often are decided very differently. Civil cases, in many instances, the presiding official can make decisions without going through a trial by jury, whereas in criminal cases, the individual's constitutional rights are protected and either require a trial by jury and the right to an attorney unless said rights are waived by the accused party. The similarities are that the U.S. Constitution protects the individual's rights to a trial by jury in both criminal and civil matters. The differences are that in civil, The matter appearing before the court can be and often is decided in court by a presiding official only. In civil matters, often the parties must pay for the representation. In criminal, the matter appearing before the court must be decided by a trial by jury unless the accused party waives the right to a trial by jury. In criminal matters, the accused party has a right to representation by an attorney regardless of ability to pay. It is possible, of course, for a defendant to be a party in both a criminal matter as well as a civil matter. Some cases have become notorious because that happened. Remember the O.J. Simpson case back in the 90s out in California? As interpreters, what is important is to gain an understanding of the differences in each matter. Furthermore, you also have to know that learning to recognize these differences allows you to know how to use and interpret the terminology appropriately. One suggestion for working interpreters is to, whenever possible, request copies of the forms used in the case, since these are extremely helpful in identifying the type of matter. Furthermore, these sample forms are excellent ways to build your working languages glossaries. Here are two samples from the Ohio Supreme Court's website. In Lesson 1, the key points to remember are: there are two bodies of law in the United States, and there are similarities and differences between criminal cases and civil cases, and how the law applies as well as the procedures used. Individual activity. Complete the exercise to identify the differences between civil and criminal case law by answering the questions in handout 1 provided. End of Lesson 1.